Certainly, one of the key questions out there facing the president is the matter of the legality of his decision, whether he should have given Congress 30 days notice before releasing those 5 detainees from Guantanamo Bay. Joining us now is the George Washington University law professor, Jonathan Turley. You're pretty firm. You believe the president broke the law.
Absolutely. The law says clearly that he has to notify Congress and give 30 days. And what the president is essentially arguing is I'm interpreting that law to mean exactly opposite of what it says, that I have the right not to do that. It's important to note, Wolf, that that provision is not limiting his power to transfer individuals. It's a simple notification provision that you find in a great variety of different laws.
Because they argue in this legal opinion that they put out, the NSC spokesperson, Caitlin Hayden, argues that the Constitution of the United States assigns to the president, quote, protecting the lives of Americans abroad and protecting U.S. soldiers. He apparently was in danger. His health was deteriorating. They had to move quickly. Otherwise, his life could have been in danger. As a result, they didn't wait 30 days with that notification.
Well, I think the answer from Congress is going to be, look, this was a process of years. Apparently, this negotiation was going on. You clearly could have notified us earlier than you did.
They say they did notify back in 2011. Okay. There was an extensive discussion with Democrats and Republicans in Congress when there was some consideration of a swap, these 5 at Guantanamo Bay, in exchange for Bergdahl. At the time, there was widespread opposition there, but they say they should not have been surprised because there earlier had been consultations.
Well, first of all, I don't think they're arguing those earlier consultations complied with the law. They're arguing that they really interpret this law as saying you never intended to limit us in this way. When I look at that law, I don't see that leeway given to the president.
Even though in the signing statement that he attached, once he signed that defense authorization bill into law, he did include these words: the executive branch must have the flexibility, among other things, to act swiftly in conducting negotiations with foreign countries regarding the circumstances of detainee transfers. That's what he said he wrote in that signing statement at the time he signed that law. That's the argument he's made. President Bush did similar kinds of things when he was president of the United States, had signing statements that would disqualify various provisions of the law.
Right. As you know, Wolf, many of us have objected to signing statements as something that is an abuse.
The Supreme Court hasn't ruled on signing statements.
They haven't.
So there's a legal question now. When the president has a signing statement, is he violating the law or not? I assume at some point that might go up to the Supreme Court.
Well, it's not a violation of law to put in a signing statement, because a signing statement is meaningless. It is basically a president saying, this is how I interpret the law. It's his actions that violate the law. And this president promised, in fact, ran on a promise not to use signing statements to negate federal law. The answer is not to sign the law, not to sign the law and say, by the way, I intend to violate this when I have to. The law here is a simple notification law, and I think that the backlash you've seen afterwards explains why notification was not given. This is a very controversial deal, and they did not want to bring Congress into the loop.
Jonathan Turley, thanks very much for coming in.
Thank you.
The president defended the Bo Bergdahl prisoner swap